Justice of the Associate Justices of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court sits en banc is now in session.
Good afternoon. Welcome to oral arguments before the California Supreme Court. The clerk may call the calendar, please.
Good afternoon. The Supreme Court of California hearing oral arguments in San Francisco on Tuesday, May 21st, 2024 at 1:30 p.m. Case number S279622. Hector Castellanos et al. Plaintiffs and respondents versus State of California et al. And appellants. Protect app-based drivers and services et al. Interveners and appellants. For respondent, Mr. Scott A. Roland. For appellants, Protect app-based drivers and services et al. Mr. Jeffrey L. And for appellants, State of California et al. Mr. Michael J. Mongan. Case number S278481, John's Grills, Inc. et al. Plaintiffs and appellants. Versus the Hartford Financial Services Group, Inc. et al. Defendants and respondents. For respondents, Ms. Anna Rose Mathewson. For appellants, Mr. Andrew F. Hurley.
Ready.
And for amicus curiae, United Policyholders, Mrs. Rani Gupta.
Ready.
Case number S275121, Peter Quach, plaintiff and respondent versus California Commerce Club, Inc. Defendant and appellant. For respondent, Mr. Nile Uvora. And for appellant, Ms. Kelly Roland Horwitz.
Ready. Thank you. Calling the first matter, Castellanos versus the State of California.
Good afternoon, and may it please the court. I'm Scott Cronland, representing the plaintiffs. This case presents a question that the court expressly left open in McPherson, whether an initiative statute conflicts with a constitutional provision that grants plenary and unlimited power to the legislature. In this case, the answer to that question is yes. Proposition 22 impermissibly conflicts with Article 14 of the Constitution by preventing the legislature from providing complete workers' compensation protections to about 1 million app-based drivers. Unlike the initiative in McPherson, Prop 22 is limiting the legislature from doing exactly what the Constitution grants the legislature the unlimited power to do. And providing such a limitation requires an initiative constitutional amendment, not an initiative statute.
Is this something that the legislature could have adopted?
We don't dispute that the legislature could have done this.
And isn't the initiative power somewhat or equally as broad?
Well, the court has harmonized grants of authority to the legislature with the background initiative power, and generally speaking, yes. But this is the rare circumstance in which the Constitution grants unlimited power to the legislature, and an initiative statute is conflicting with the Constitution by limiting the legislature's unlimited power.
What supports that position? What supports that position? I mean, it seems to me that one of the fundamental questions here revolves around whether or not the grant with respect to Article 14 is one that precludes what is normally a sort of a sharing of legislative power reserved through the initiative process. What in the language of the provision supports that argument?
The amendment that added Article 14 was adopted in 1918. At that time, the initiative power was already in the Constitution, and as this court said in Barlotti, a 1920 case, the Constitution could not be more clear than in distinguishing between the legislature and the initiative power. The grant in Article 14 is to the legislature. And it's true that in other cases, the court has been able to harmonize the reserved power of the people to adopt initiatives with power granted to the legislature. But those cases aren't based on the meaning of the word legislature. They're based on an attempt to harmonize all the provisions of the Constitution. And in this case, it's not possible to harmonize this particular initiative with the constitutional grant of authority because the Constitution grants the legislature unlimited authority to protect any workers with a complete workers' compensation system, and the initiative is preventing the legislature from doing that, effectively repealing the constitutional
So I guess one
grant.
question is, what does unlimited mean in this phrase? And you've heard arguments about whether unlimited really means unlimited. Unlimited by the governor's signing authority and ultimate veto authority? Is that encompassed by unlimited?
The meaning should be determined by what the voters would have understood when they approved the amendment in 1918. And they would have understood that they were granting the legislature the authority to adopt legislation by the normal means of adopting legislation, which includes bicameralism, presentment to the governor. This court recognized that in the County of Los Angeles case. It recognized that a subsequent constitutional amendment that required the legislature to get a supermajority vote in order to raise workers' compensation benefits would conflict with Article 14 because it would put workers' compensation benefits in a separate class of legislation that couldn't be adopted by the normal means.
So what is your evidence that in 1918, when this was adopted, the voters didn't have in mind the initiative power?
Well, it's not that they didn't have in mind the initiative power, it's that they would have understood that there was a difference between initiative statutes and initiative constitutional amendments, and that authority that's put in by amendment needs to be taken out by constitutional amendment. Article 14 wasn't just saying the existing workers' comp system is hereby declared to be constitutional. It was vesting in the legislature an authority that could be used in the future to protect workers because the economy would change. The workers' comp statutes had already been amended many times between 1911 and 1918, and in effect, the voters were pre-approving whatever amendments would be necessary to protect workers.
Yeah, that's all true, but why is that to the exclusion of the initiative power?
It's to the exclusion of an initiative statute that would prevent the legislature from protecting workers.
Here, even though it may be difficult, isn't it theoretically possible for the legislature to still provide workers' comp benefits to this category of workers?
It's not possible because the provision that was adopted, Section 7451, says, notwithstanding any provision of law, these workers are not employees entitled to workers' comp. Prop 22 says Section 7451 cannot be amended. And therefore, without going back to the ballot, it isn't possible for the legislature to do what the Constitution says that the legislature has the unlimited
Well, 7451 actually doesn't talk about workers' comp, does it?
It's not specific to workers' comp, but it says for purposes of the labor code.
Well, I want to come back to that, but before we get to what the initiative statute means, I just want to hear a more complete answer to why wouldn't the voters in 1918 have just simply understood the structure of government as it existed in 1918 to be the framework, just as you said, that they would have understood bicameralism and presentment as the necessary prerequisites to enacting quote-unquote appropriate legislation. The same argument applies, which is that legislation is subject to the checks and balances that had just been put into the Constitution in 1911.
They wouldn't have understood that the decision they were making to amend the Constitution could be countermanded without another constitutional amendment. That's one reason you put things in the Constitution. There are two types of initiatives. They were granting to the legislature unlimited power. The legislature didn't have to come back and ask the voters, can we change the workers' comp system in the future? Can we protect these workers? The legislature had the pre-approval to do that.
Could you address if we were to adopt your position, the other side is arguing that this would give the legislature what's been described as a first mover advantage, allowing its initial policy choices to then freeze out any efforts by the voters to enact anything that would be contradictory to those policy choices.
Yes, with respect to workers' compensation, the power granted to the legislature can only be withdrawn by an initiative constitutional amendment. The legislature put the amendment on the ballot asking the people to trust the legislature to protect workers in the future, to grant it unlimited power. That's what the provision says. And the power could be withdrawn by the same majority vote by which it was granted. But the people have to be asked, do you want to amend the Constitution to limit the legislature's Article 14 power?
I guess, well, there's still, I feel like there's still an ambiguity there. So the Chief's question concerns a situation perhaps where the legislature acts, right, in the field of workers' compensation. But does that mean that the voters, is it your position that the voters simply cannot act in this field whatsoever, even making policy choices that may support, buttress, affirm, be consonant with, or at least not inconsistent with, what the legislature has done?
Well, in light of the court's reasoning in McPherson, the voters could adopt non-conflicting statutory initiatives in the field of workers' compensation. The holding of McPherson is that plenary power doesn't have to be exclusive power, but unlimited power can't be limited power.
There are arguments from your friends on the other side about McPherson and the idea of conflict, that the voters' decision in McPherson actually was conflicting with the decision made by the legislature insofar as the legislature had decided that PUC authority should extend this far and not farther. So the consequence of a rule that would say that the voters and the legislature can occupy the same space as long as there's no conflict would create a sort of one-way ratchet system. And I guess I am wondering what your response is to that. How is this situation we're confronting here fundamentally different from a situation in which the voters and the legislature are making different choices about how far legislation in a particular area should extend?
The premise of the court's decision in McPherson was that there was no conflict. The court said it expressly in footnote 9. It said it was saying that to avoid any misunderstanding about its holding. So the argument that there was a conflict is an argument that was not made in McPherson, and that the court expressly said that it wasn't considering. The proposition of McPherson had failed at the polls.
I'm wondering how expansive your notion of this term unlimited is. As you've heard from my colleagues, it seems like this case really turns in many ways on what unlimited by the Constitution means. To give an extreme, for example, would you say that the legislature could act in the field of workers' comp in a way that clearly violates the Equal Protection Clause, for example, and the California state constitution would have nothing to say about it? So legislation that says workers' comp only for men, would your argument be, yes, they can act in this space in a way unlimited by the Constitution, federal Constitution, of course, may have something different to say about it, but vis-a-vis the state Constitution, that'd be fine?
In a world in which we assume there's no federal Constitution, then yes, with the caveat that in Houston, the court said the Article 14 power is the power to do what's necessary to effectuate the objectives of Article 14. And maybe there's some argument that what the legislature did isn't necessary to further the objectives of Article 14. But otherwise, yes, unlimited means unlimited by any provision of this Constitution. It's exactly what it says and what it meant
It's just, it is a highly technical parsing of what the voters must have thought in the early 1900s, because under your reasoning, anything that abrogates something as substantive as the Equal Protection Clause was fair game to be cast aside. But of course, the governor's veto power, that's different, and the legislature and the voters would have understood that that's not included in the definition of unlimited. Apropos of my colleague's questions, how do we get to this kind of parsing of the language to get it intent?
Well, what Article 14, Section 4 says is that the legislature has to exercise its unlimited power by appropriate legislation. Legislation then, just as today, means both houses of the legislature have to vote on it, and it has to survive the veto. That's the normal process, majority vote, no veto. And that would have been understood at the time, just as it's understood today what appropriate legislation means. What it wouldn't have been understood to mean is that the legislature adopts legislation that provides these million workers with workers' comp, which they've done both before and after Prop 22, and yet those statutes are unenforceable. That's not compatible with the legislature having unlimited power to provide workers' compensation for any or all workers. That the two statutes the legislature did adopt before and after Prop 22 are rendered unenforceable.
I guess, so I return to Justice Kruger's question about the one-way ratchet. I mean, this, you used the word conflict earlier, and I guess not really sure what the definition of a conflict would be, but suppose that the legislature in AB 5 had simply carved out app-based workers, right? They're not covered. But the electorate, contrary to Prop 22, decided to cover them. Is that a conflict?
Yes, if the statutes passed by the legislature actually said these workers are excluded, rather than a statutory initiative, you'd need to do it as an initiative constitutional amendment to change Article 14 and take it away from the legislature. All we mean by a conflict is that you can't comply with both, which is the situation here. The court doesn't have to reach it to decide this case. As in McPherson, you don't have to anticipate every possibility. This issue hasn't come up for a century. But certainly in this case, there's not only a conflict with the terms of what the legislature adopted, but what the legislature is doing is exactly what the voters declared was the social public policy of the state, which is providing workers' compensation. And the initiative is not. The initiative is not providing a complete system of workers' compensation. It's creating a separate, incomplete system, throwing the app drivers in there, and preventing the legislature from doing what the Constitution granted the legislature the authority to do.
Okay, so let's go there then. So the statute, right, the initiative statute, does not by its terms speak of workers' compensation. You're aware there are other statutes that the legislature has passed that has offered essentially employee benefits to some independent contractors?
Yes, the legislature can offer employee benefits.
And could it not do that again here?
You're asking whether in light of this proposition the legislature could pass a statute that gives... No, because that would be considered an impermissible amendment to Prop 22 if they gave complete workers' comp protections to the app drivers but called them something other than employee. That would clearly be an impermissible amendment to Prop 22.
Why would it be clearly impermissible? I mean, I guess that's where I don't dispute with you that the intent of at least the proponents of Prop 22 was to, essentially reverse, right, their possible status as employees. But that is not actually what the language of the disputed section says, right? The disputed section only speaks of the classification as employees or independent contractors for purposes of the labor code. But the labor code is not frozen in time. The legislature frequently revisits the labor code. And we just had a case last year about whether or not what do we do about provisions that do or don't lock in, right, particular understandings of the background law at the time. And there's no lock-in provision here. So if you just go by the text of the initiative, it doesn't really say anything about workers' compensation. I understand the intent behind it. Any citizen would, right? But the point is, we start with the text. And isn't that what is actually the law here?
The text is the law, but what Prop 22 is saying when it says that these workers are not employees for purposes of the labor code is that they're not covered by any of the protections that apply to employees. Employee is just a coverage word. It means different things for different purposes. And what Section 7451 is saying is that notwithstanding anything in the labor code, these workers are not employees covered by any of these protections.
I'm just curious why commit or concede on this point now? That is to say, you hear the questions from my colleague pointing out the initiative itself doesn't even specifically address workers' compensation. We've said before that the legislature remains free to act on a matter related to initiative that was not specifically, that the initiative measure does not specifically authorize or prohibit. We're sort of in an abstract world of if the legislature were to do X, Y, or Z, would they be able to, vis-a-vis giving workers' comp to app-based drivers. I hear you quite clearly to be saying the legislature can't. They just can't. Why commit to that position now?
Well, if the court wants to make clear that the legislature can give these workers back all the benefits they lost by using different words, we would be very happy with that.
But you just said no, that wouldn't be characterization. You just said no, that wouldn't be accurate.
Well, this case was decided on the premise that by saying that these workers are not employees entitled to all of these protections and that the provision that takes them out can't be amended, that they're stuck out of getting all the employee protections.
Two things. One is, first of all, we're not presented with any legislation in this case. And so it's very hard to evaluate in the abstract, what kind of legislation the legislature might actually enact that would or would not be in conflict with 7451, right? In some sense, the question that we're debating is not even before us. And so Justice Groban, I think, is appropriately asking, why are we, why would you or why would we commit to any possible position on that question before we were actually having to examine a piece of legislation? And secondly, I think, the framework, of course, that Prop 22 through 7451 tries to set forth, employee versus independent contractor. Of course, that's a very well-trod distinction in the law. But the legislature adjusts and can adjust what kind of things attach, to each bucket endlessly. There's many permutations of this, overtime, workers' comp, other workers' protections, right? If there was an intent to lock in the state of the law at the time that this initiative was passed, it is certainly not apparent from the face of the statute. And so it would, I think, there would be a decent argument, I'm not committing to it, but there would be a decent argument that absent a lock-in provision, you take the background law as you find it, and it evolves over time. And it's not the legislature using semantics. It's that you take the law as you find it, and the legislature is going to legislate against what is now part of the law. Why couldn't it do that?
Well, I think the legislature has done that. In 2023, the legislature adopted AB 1766, which reiterates that the app-based drivers are entitled to workers' compensation benefits. So if the legislature has the power to do that, then it's done that. And Section 7451 can't be applied to workers' compensation benefits. We certainly don't want to foreclose the legislature from doing good things in the future, but I'm sure that unless this court makes it expressly clear, because Prop 22 provides an alternative set of inferior benefits to these app drivers, that if the legislature does try to give them back any of the employee-type benefits, it's going to be challenged by the app companies and in all likelihood struck down by the lower courts.
I have a question in a different area. I wanted to focus on the language of Section 14, and it talks about the legislature's plenary power, unlimited by any provision of this Constitution. You quoted that earlier. I'm wondering how you define that and what you are interpreting that to mean. It seems that you're interpreting it to mean unlimited by any initiative that's enacted pursuant to a provision of the Constitution. But that's not exactly what the constitutional provision says. So I'm wondering how you interpreted it.
Well, first, it would be unlimited by Article 2, Section 10, which precludes the legislature from amending initiatives unless the initiative permits amendment. This initiative doesn't permit 7451 from being amended. So our argument is that 7451 is inconsistent with Article 14 and preventing future legislatures from giving workers' compensation benefits to the app drivers, which is what the trial court held in its decision below. And in addition, it's our view that when the legislature is acting pursuant to its unlimited Article 14 power, the only thing in state law that can stop it is another constitutional amendment because it's acting with its unlimited Article 14 power.
You're right at your time. You've requested 5 minutes of rebuttal.
Thank you, Your Honor.
May it please the court, I'm Jeff Fisher on behalf of the interveners. This court has held time and again that provisions of the Constitution that vest the legislature with power, even plenary power, to pass laws on a given subject, also include the right of the people to pass initiatives on that subject. Applying that principle here yields a straightforward result. The legislature could have passed Proposition 22, therefore, so could the people. Now, my friend's argument, I think, boils down to just a single phrase in Article 14, Section 4. That is the phrase we've been talking about, which says the legislature's power is unlimited by any other provision in this Constitution. But in McPherson, the court already addressed that very same language and held that it does not mean what my friend says it means. Instead, all it does is sweep away other substantive restrictions on the legislative power. It does not scotch out the governor's veto. It does not scotch out other fundamental structural checks in the California Constitution, like the right to initiative. And there would be no reason why the people would have done that in Article 14, Section 4. The California Constitution lets the people through their initiative power legislate on any number of subjects, whether it be tax policy, criminal justice, environmental policy. And I think my friends have conceded in their briefing that in the early 1900s, when Article 14 was enacted, there was no conversation at all about limiting the power of the people to enact things by initiative. Instead, all that was designed to do was sweep away Lochner restrictions that might have otherwise gotten in the way of workers' comp legislation. So that objective is readily achievable by simply holding that Article 14, Section 4 is not limited by any kind of Lochner theory that might otherwise lurk in the California Constitution and letting all the other structural provisions of the Constitution stay in place.
Mr. Fisher, can I ask you, could the voters by initiative eliminate workers' compensation altogether and thus foreclose the legislature from coming back and reenacting some or all of the current workers' compensation system?
I think, Justice Kruger, the answer to that theoretical question is yes, just as the legislature itself could eliminate workers' compensation under the language of Article 14, Section 4, that says any or all workers and leaves it up to the legislature to create it. But I'd hasten to add, if you have any concern about that, we're miles away from that kind of a situation here. You could even reserve that in the opinion if you would like. I think what this situation is like is what the legislature itself did after AB 5 and the subsequent law, AB 2257, where it backed out various workers from the ABC classification system, like wedding planners and other insurance inspectors and other workers. And the legislature had the power to do that. And here, the people have just backed out one other category of workers from the ABC system.
But of course, this is a question about the scope of the legislature's power, right, to further the social policy that is recognized by the text of Section 14. So I guess I'm wondering how you would articulate what general principle we would look to articulate the distinction between the sort of extreme scenario and the scenario where the voters are approximating exceptions that the legislature might enact on its own.
I don't know that there is a principle, Justice Kruger, other than if you thought there was a qualitative difference between zeroing it out and just having some workers not eligible for workers' compensation. My core position as I stand here today is whatever the legislature can do, the people can do. And I think the legislature could say nobody gets workers' compensation, notwithstanding Article 14. All it did was give it the power to give workers' compensation to workers. It didn't command that anybody have it. And so the people would have the same power. I don't think there's any realistic chance.
What about the concern about first mover advantages?
Well, I think first mover advantages, Justice Liu, I think you articulated, the other side, I think, has the problem with first mover advantages because it would block out the people from exercising their traditional initiative power. What we think is that the legislature can act or the people can act first. And all I'm saying is that the people ultimately have the power to command their policy views via initiative. And that whether that's as my friend puts it, consistent with what the legislature has done before or inconsistent. And I think that brings me back to Justice Kruger's question earlier about the this much and no more principle. You know, even if there were some notion of being inconsistent with the legislature, whenever the legislature grants any workers' comp, it's this much and no more. Imagine a provision that said workers can recover $1,000 for a particular kind of injury. And if the people came in and said, well, we'd like it to be $2,000, I think that would be inconsistent.
Well, no, what I mean is, I know you're trying to draw a certain symmetry between the legislature's power and the initiative power, but the two powers are not exactly symmetrical in the sense that in the case of the initiative power, when something is done by initiative, there are certain rules that attend the prospect of reversing what is done by initiative, and that tends to favor the initiative.
Fair enough.
Right, so that's what I mean by first mover advantage, because then there are certain procedural hurdles that don't exist in the other direction when the legislature passes ordinary legislation that can then be reversed by initiative.
I think I agree with everything you said, and you've just described the structure of the California Constitution, which is the people in the legislature.
Which is why one might suspect there's a little bit of tension in your reading, because why would the voters have said unlimited if they meant to subject the legislature's power, right, to this you could call it first mover advantage, but it's actually kind of like slightly one hand tied behind your back when it comes to legislating in this field as between the initiative power and the legislative power.
I think there's a very good reason, and you can look to history, which is the 1911 provision that was at issue in McPherson used exactly the same word. And what the court said in McPherson was the word unlimited was not meant to get rid of the governor's veto or other structural checks on the legislature. It was just meant to get around any other substantive restriction on legislative authority. There it was the possible rate-making limitations in the California Constitution. And here, the history is crystal clear. It's the worry that Lochner theories lurking in the California Constitution would have gotten in the way of workers' compensation. So that's what the word unlimited does. It does something very important, but that's all that it does.
I wonder, though, if we've been focusing on the word unlimited, maybe we should talk about the word plenary. I understand that we've held before that plenary doesn't mean exclusive, but it must mean something. I wonder if you're back and forth here with my colleagues does some damage to the traditional understanding of plenary, because I understand you to be saying if the people through initiative took a big swing and just got rid of workers' comp altogether, there's not much the legislature could do about it, which turns plenary into it's plenary until it's nothing. Until it's nothing. That doesn't feel very plenary to me.
Well, two things about the word plenary. One is in Kempton, the court said if the legislature has plenary power, so do the people. That's our position. And also, as the state points out in its briefing, the court itself has held that the plenary power includes the power to abrogate. And so that is what plenary power means, is legislature can put people into a system, they can classify them in one way or the other, and they can go the other direction too. And all we're saying here today is the people have the same power that the legislature does. And I think that brings me to footnote 9, which is what my friend started with. And we think this isn't a footnote 9 case at all. All you reserved in footnote 9 in McPherson was a special situation that might have arisen under that constitutional provision that gave legislative authority only to add additional powers to the PUC. So if the people had taken powers away from the PUC under the plain text of that constitutional provision, you might have had a question, just as you would have if the legislature itself had taken power away from the PUC. You might have had a question whether that was permissible. But here I think everybody agrees that the legislature can move the ratchet in both directions. And all we're saying, as I said, is that the people can do the same thing. And I think that brings me also, Justice Liu, you asked about potential future legislation. And I think there'd be two questions that would arise if the legislature were to step back in and say, we want to put app-based drivers, we want to give app-based drivers workers' compensation benefits. The first question would be whether that was an amendment. I think that's what you've already recognized. The question would be whether that was an amendment to Proposition 22. We would argue that it would be, but it's hypothetical legislation, and I grant you that until you have actual legislation before you, you may not consider that question to be ripe. Secondly, you'd have the question whether if it were an amendment, the people would have the power under Article 2, Section 10 to have it put in front of it before it became law. And I think that's the singular point of divergence between us and the state in this case. And so I'll just speak to that quickly if the court would like me to. And our position is that Article 2, Section 10 does survive Article 14, Section 4 under the structure of the California Constitution, which in Article 2, Section 1 gives the people all political power, and in Article 4, Section 1 expressly reserves the power of the initiative as against the legislative power. And so under those provisions and under just basic structural principles of the Constitution that even the state recognizes with respect to the governor's veto power, that power would survive.
What about
Article
the County
14.
of Los Angeles case?
So I think the County of Los Angeles case is the only thing that the other side has to point to, but it's readily distinguishable in three ways, Justice Liu. First of all, the court didn't even reach the question in this County of Los Angeles case because it harmonized the constitutional provisions, so it didn't find any conflict. Second of all, the supermajority rule that was at issue in that case was also tied, as the court itself was clear to put it, to a substantive restriction of that required the legislature in revenue-raising situations to do the revenue raising for itself. And so it wasn't purely a procedural limitation on the legislative power. And then finally, and this may be the most important and the easiest way to deal with County of Los Angeles, a supermajority voting requirement for the legislature is just another rule about how legislation gets made. It's not a structural check existing elsewhere in the Constitution. And as I take the lesson of McPherson in the court's broader case law, it's that whenever you talk about unlimited power or any other plenary legislative power or anything else as against the power of the people, the structural checks survive. There's just, with all due respect, there's no way to distinguish the governor's veto from Article 2, Section 10. Article 2, Section 10 is the people's veto, which is in some ways even more influential and structurally fundamental to the California Constitution.
But you're generally in agreement, I guess, with the attorney. We'll hear from the Attorney General, I suppose, but that these questions, all the ones you've just been discussing, are really not before us at the moment. And to the extent we're going to test them, they should be tested in the context of legislation that actually gets enacted, where we know the shape and form of what the legislature wants to do. And at that point, we can evaluate whether there's any inconsistency or amendment of Section 7451.
Yeah, I don't think we disagree that that question, strictly speaking, is not ripe because there is no legislation before you. I'll simply add two things, if I may. One is, remember that this argument has been threaded throughout this case. It was the basis of the trial court's decision. So I think if you wanted to say something about it here, and I think the way we would put it, if you want to make clear that the Article 2, Section 10 power survives Article 14 and was not impliedly pro tanto repealed, I think you'd be within your within bounds to do so, and maybe fend off some mischief that might come from reserving too much, as you might have done, inadvertently perhaps in footnote 9 of McPherson. So I think you could make that clear if you wanted. The other thing I would like to add is that just given the way this case has unfolded, where the state for the first time presented this argument on the Article 2, Section 10 piece of it, in its answer brief, which was simultaneously filed with our brief, we've just never had a chance to answer that argument in writing. And so if you have any questions about the correctness of what I've stated here orally today, we would just respectfully ask the court an opportunity to brief the issue in writing before the court decided it against us. If the court has no other questions, I'm happy to submit the case.
Thank you.
Thank you.
Good afternoon, and may it please the court, Mike Mongan for the state. The issue presented here involves a live controversy over whether the voters' enactment of Business and Professions Code Section 7451 conflicts with Article 14, Section 4 of the state constitution. And the answer is no. Under Section 7451's classification test for app-based drivers, most drivers are likely to be independent contractors who don't get workers' compensation under present law. But Section 4 does not prohibit laws that exclude certain workers from workers' compensation. And although Section 4 is a grant of plenary power to the legislature on this subject, this court has recognized that plenary does not mean exclusive, and that the type of language found in Section 4 is not sufficient by itself to withdraw the voter's own precious power to make laws by initiative. The court can resolve the issue presented and uphold Section 7451 on that basis. Now, you've also received argument about a more hypothetical future controversy, whether a future legislature could amend Section 7451 with respect to workers' compensation or otherwise provide workers' compensation to app-based drivers. But there's no concrete legislative proposal like that on the table. So to answer that question, as Justice Liu suggested, the court would have to speculate about what that amendment might look like, and then analyze constitutional and statutory provisions that are outside the scope of the issue presented here. In the state's view, there are powerful arguments that Section 4 preserves prospective authority for the legislature to amend voter initiatives on workers' compensation through its normal procedures. But it would be better for the court to reserve that issue for a future case presenting a live dispute over an actual legislative proposal or enactment. Now, Your Honors, there are a number of arguments that have been made about how that hypothetical would play out. I'm happy to address those, but I thought if it pleases the court, I would start with the issue that we think is squarely before the court. And I would like to address briefly the description I heard earlier from plaintiffs about the McPherson case. I think McPherson really is on all fours with this case. And to understand it, we need to consider the context of that decision. The court was dealing with a prior legislative enactment during the deregulation era where the legislature had exercised its power under Article 12, Section 5, and said with respect to a certain entity, an independent electric service provider, that these entities would not be subject to regulation as to rates and terms of service, but would have to register and be licensed by the PUC. That was a considered legislative judgment, and the proposition that this court considered in McPherson, Proposition 80, would have countermanded it. Instead of allowing them to freely compete, it would have directed the PUC to regulate those entities with respect to rates and terms of service. So I think that McPherson was dealing with a situation with respect to my friend's argument where the voters had considered and countermanded a legislative judgment, and that was not a cause of concern for the court. But Your Honor, even if you disagree with that reading, and you think that footnote 9 in McPherson is broader than that and was meant to reserve this type of scenario, it's clear that footnote 9 was not meant to answer the question. And so that would just bring us to the first principles in this area. And the first principle is that the voters generally have broad power to make laws via initiative. And the general view is that that extends to the full scope of subject matter that the legislature can make laws on, unless there's some clear indication to the contrary in the constitutional text or perhaps in history. And McPherson looked at the very same language that plaintiffs are pointing to here, the plenary and unlimited language in the very similar context of Article 12, Section 5, and said it wasn't enough, at least by itself, to withdraw the voters' initiative power. Then McPherson looked to the history, and there, as here, there's nothing in the history indicating that the intent of that enactment was to withdraw the voters' initiative power in the way that has been described by plaintiffs. I think if you reach that conclusion, as we do, then the only question becomes whether this is an enactment, Section 7451, that the legislature could pass. And this court has said quite clearly in cases like Matthews and Borrello that there is a legislative power here to direct that certain classes of workers are not entitled to workers' compensation. And so far as the court's inquiry into the constitutionality of Section 7451 goes, I think that's dispositive, and the court could uphold Section 7451 on that basis. Now, Your Honor, if I might, say a word about the question of the meaning of this unlimited clause, because if the court were to entertain the more far-reaching questions about the legislature's prospective authority, which we think it should not reach in this case, that would be of central relevance. And I'll grant you, it's a difficult question. But this court's precedent do shed some light on the meaning of that clause. I think it's clear from Husted that it can't be taken to its literal fullest extent, because there the court applied the separation of powers principle in Article 3, Section 3. And of course, we've all recognized that there are certain other provisions that would apply. But the court's precedent, and particularly County of Los Angeles, recognizes that it has to mean something. It's not just the superfluity canon, it's that this court, in an extensive discussion of the scope of Article 14, Section 4, indicated that it would be a constitutional problem if there were another constitutional provision that would apply and substantially interfere with the ability of the legislature to make laws on workers' compensation policy in the future. And the issue there was the potential application of a 2/3 supermajority requirement. If that would be constitutionally problematic, I think it follows that the application of a provision like Article 2, Section 10C, which would effectively say to the legislature that in a zone of lawmaking where the Constitution says you have plenary and, quote, unlimited powers, you may not make any changes as to aspects of workers' compensation policy without the approval of the voters, would be equally, if not more, problematic. So if and when that case comes presenting that issue, our view would be that this is a narrow corner of the state constitution where the legislature has an ability to amend voter initiatives with respect to workers' compensation through its normal procedures. And part of that flows from the text of the grant here. It's not just the express and plenary and unlimited language, but the fact, Your Honor, that it speaks in prospective terms. It talks about the power of the legislature, not just to create a workers' compensation system, but to enforce it, to manage aspects of it, to adjust benefits to make sure that they are requisite and adequate as circumstances change in the future. We know the legislature has had an active role, including in circumstances like the COVID pandemic, where it had to move quite quickly. And the...
Could I pause? This is very helpful. We don't have to opine on all of these things, as you said, but since we're here and we're discussing it, let me ask you this question.
Sure.
Your position on Article 2, Section 10, I mean, I understand what you're saying. Why is that? Is that in some tension with your initial position, which is to say, your initial position was that unlimited doesn't mean totally unlimited because it encompasses the initiative power, or that there's no sign that the voters intended to screen off the initiative power. But why wouldn't it also take as given another structural provision, which is essentially Article 2, Section 10? Isn't that meant also as part of the checks and balances that inhere in the constitutional structure?
Well, here's why we would lead to a different conclusion in this particular area, Your Honor. It's because the voters' mere exercise of statutory initiative power with respect to workers' compensation does not by itself substantially interfere with the legislature's forward-looking lawmaking prerogatives. And we're deciding or considering this case against a backdrop of very robust precedent saying we should jealously protect the initiative power and resolve all doubts in its favor. On the other hand, the potential application of Article 2, Section 10C would present a very different question. It would substantially interfere with the legislature's ability to carry out its lawmaking responsibilities in this area. And, Your Honor, if I could step back, I would suggest that this is a difficult case if you get to those prospective questions, but the reason it's difficult is because there are competing constitutional principles and powers of both the legislature and the voters in the mix. And the great advantage of the position we're advocating today is that it would honor the ability of the voters to make laws by initiative in an important area of state policy, while also at least reserving the possibility that the legislature, where it deems appropriate, could make adjustments to
I understand you're not asking us to necessarily go whole hog on all these questions to the very last logical step, but there is a whiff, I think, in your argument that these two positions are linked, which is to say you're able to tell us that the initiative power is preserved under the unlimited clause, in part because you think the Article 2, Section 10 power is not, in a way.
I think that it is important in informing an overarching understanding of how the Constitution should operate in this area, Your Honor. And as it relates to the issue that was formally presented in this case, we don't think that you need to reach the question of what implications the upholding of Section 7451 would have for
I understand.
Right.
I'm just saying if we were, again, this is forecasting, well beyond what's before us, but if it were the case that proponents were correct that Article 2, Section 10 does continue in operation, notwithstanding the unlimited clause, that might put a very different cast on what it means to preserve the initiative power in this, because it would be very hard, in other words, for the legislature to repeal an initiative. Or it would subject it essentially to the same kind of structural check that the initiative power represents.
Right. Well, and I guess what I would say, and I hope that this is not unhelpful, is that's a powerful reason to not rule the other way with respect to the application of 10C, and at least reserve in the court's opinion that that is an open question that would be subject to litigation in a future case.
Perhaps a different way to get at the same issue is the same question that I think Justice Kruger put to your colleague, which is, could the people by initiative just abolish workers' compensation altogether?
So I think that highlights the difference of opinion perhaps with myself and interveners. Of course, they could do it by constitutional initiative, and I think my answer is whether they could do it by a statutory initiative. I'd give you the same answer as if you were asking whether the legislature could do it. Yes, I think current precedent suggests that they could, but it would be deeply problematic if the consequence of that would be that then the legislature would be frozen out of restoring the workers' compensation system in an area where the Constitution expressly vests it with plenary and forward-looking authority. And that would all be the result in that hypothetical of a statutory initiative by the voters.
You've heard the argument that requiring voter approval for prospective legislative changes in this area is not different in kind for purposes of the interpretation of this constitutional provision from requiring the approval or non-veto of the governor. What is your response to that?
I disagree with that. I'll try and give a direct response, and if I could say a word about the broader structural argument. I think I agree with plaintiffs on this point, that when you're contemplating the ordinary steps that the legislature always has to go through to pass any enactment, the roll call vote, a reading of the bill, presentment to the governor for the possibility of veto, that is contemplated here. It wouldn't make sense to read Section 4 as excluding those provisions. But County of Los Angeles teaches that when you go beyond that and you're talking about something that could much more substantially interfere with the ordinary lawmaking activities of the legislature, that's a different story. And I think there are some material differences between presenting to the governor for a veto and the Article 2, Section 10C scenario, not just that it applies in every law, but also because the Constitution contemplates that there's a sort of straightforward, time-limited opportunity for it to go to the governor, and then the legislature has a possibility to consider an override, whereas when you're dealing with the prospect of sending a potential change to a statutory initiative to the voters for approval, you're talking of a much, much longer time period and a much more substantial and difficult process, which seems at least a greater burden than what was contemplated by the court in County of Los Angeles. And if I could just say briefly, the sort of structural gloss on what unlimited means, I'm not sure where the support for that comes in text and history and precedent, and it seems like it might be over-inclusive in some respects and under-inclusive in others, in the sense that it wouldn't address the 10C problem that I'm describing, but also I think there are some provisions like the roll call vote requirement that I'm not sure would be described as structural, but would be excluded on that interpretation.
Could I just ask in your remaining time, does the Attorney General have a position on what it means to amend 7451?
We haven't taken a position on that, but I would note the questions from earlier in the argument. I think they are difficult ones if you're contemplating something that does not change the text of 7451, but instead is trying to provide workers' compensation, perhaps through an amendment to the labor code to some or all app-based drivers. You'd have to apply this court's precedent in cases like Rojas to the particular enactment to determine whether that's an amendment, and it's very hard to do that in this posture where we don't have any particular proposal.
Thank you very much, Solicitor General Mongan. Your time has expired.
Thank you.
Thank you. Very briefly, if the court is going to decide this case on the premise that the legislature could restore the app drivers to the workers' compensation system, that is, that the trial court was incorrect in believing that 7451 was a continuing limitation on the authority of the legislature, and the Court of Appeal was incorrect, and the state was incorrect, and everyone was incorrect below. We would ask that if that's the premise, that the court provide guidance, because right now, Prop 22 says that this section cannot be amended, that any amendments have to be made, even not of this section, 7451, by 7/8 vote, and that they can only be amendments that further the stated purposes of Prop 22, which seem to be depriving the workers of the employee protections. So if, as been suggested, the premise of the court's decision is that the legislature could restore these protections, we would ask that the court provide guidance, because otherwise...
I'm not sure what guidance we can provide beyond... I mean, we do have a body of case law on what it means to amend an initiative statute.
You do, and everyone agreed below that that body of case law would prevent the legislature from putting these workers back in the workers' comp system when it's the clear intent, it appears, of Prop 22 to take them out, and that's what the gig companies will argue. I'd also suggest that the state's view that it's possible to construe 10C and the amendment provision to allow the legislature to put the workers back in the workers' comp system, perhaps, is exactly what the voters didn't want in adopting Prop 22. And we see that from the non-severability provision and the amendment provision. The non-severability provision says that if 7451 is invalid in any application, including its application to future legislation, like an amendment to the labor code that puts the workers in, like the one in 2023, then they didn't want any of the provisions of Prop 22 to take effect. Likewise, the amendment provision says that this provision, 7451, can't be amended at all. So, the drafters of Prop 22 put it on the ballot as an all or nothing proposition. And what's being suggested is there's sort of a way around the non-severability provision that would allow the workers to receive workers' comp protections, yet the rest of Prop 22 would survive. That's exactly what the voters said that they didn't want in Prop 22. They wanted all or nothing.
What do you make of the alternate, I guess it's an alternative position, that the better way to test these things not only is when legislation has been passed, but it's to assess the meaning of unlimited, right, in the context of future legislation, and as to whether or not it has to satisfy Article 2, Section 10. I take it your answer is it doesn't.
Well, I would say two things. First, we have that legislation. AB 1766, passed in 2023, changes the statute that deals with eligibility for workers' compensation to clarify that the test in the amendment to AB 5 applies, under which these workers are entitled to workers' comp. So if the legislature can pass post-Prop 22 legislation that gives people workers' comp, it did that already. That should be effective. And under the non-severability clause, we shouldn't have Prop 22. And second, as I said, unless this court clarifies that the legislature can do what the Constitution and Prop 22 say the legislature can't do, it's never going to happen. There won't be any case to test that in. Rather, the 7/8 vote requirement, the in furtherance of statement, and the provision that nothing that amends 7451 furthers the purposes of Prop 22 means that we will never have that legislation, and it won't be tested.
Mr. Carlin, your time is right about at the expiration point. Would you like to wrap up quickly?
Unless the court has questions, we think the trial court got this right, and we would urge the court to affirm the trial court decision.
Thank you. Thank you to all counsel for your very helpful arguments here today. The matter is not being submitted yet because we have outstanding briefing, but thank you for your arguments.